Anish for the introduction. Hi everyone, good afternoon. I'm Smita. I'm an associate partner at Lexstart and I currently head the commercial contracts team. I have a team of 10 brilliant lawyers who help me ensure that all our clients on our roster are adequately protected when it comes to their contracts. So what we'll be doing essentially is, and when we were approached with this idea of mentoring all of you, we were extremely excited and delighted to have this opportunity because, look, it resonates a lot with the firm ethos. The idea of basically starting Lexstart came into picture because our founder felt there was a significant gap that existed, wherein the startup ecosystem wasn't being catered to. And especially what we've noticed in our 7-year stint is that especially early stage startups are the ones who tend to overlook contracts until funding actually happens. So it is only when an institutional round happens and, the VC fund immediately pulls up the company saying that, where are your contracts? Why aren't these in place? We've noticed a lot of our clients come there. But we've also noticed the contrary view wherein the companies are extremely aware that, they need to have contracts in place. They'd rather be proactive as opposed to being reactive and come to us and just ensure that we keep their house in order. And that's where my team and I step in. We help the clients with their day-to-day requirements, whether it's their contracts with their internal or external stakeholders. We help with all of that. So before we jump into the actual presentation, which is effectively on tech contracts, I just thought we'd give a brief introduction about Lexstart as a firm, what we actually do. So we have two other verticals other than the commercial contracts vertical, which is headed by me. There's the transaction advisory vertical. I believe Pradyuman had given a basic introduction on the process of funding last week. So basically, he's one of the team leads who are supervised by our founder, Ms. Anisha Patnaik. Essentially, that team's goal is to ensure that they help you right from the term sheet stage to actually when the money hits the account. So this includes all of your assistance when it comes to drafting the term sheet, negotiating the term sheet, your transaction documents, whether it is drafting or reviewing, and finally, with all of your closing related formalities to ensure that the money can actually be used by you. So that is what the transaction advisory team does. We also have an ESOP and corporate compliance team whose basic role is to ensure that all of your compliances under the Companies Act, the FEMA regulations, all of those are in place. So when a funding round actually happens, or even for your day-to-day requirements, for instance, your board meetings, your shareholder meetings, your filings with the ROC for appointment of directors, for allotment of shares, all of that is handled in-house by our team of company secretaries. And within that team, we also have an in-house ESOP expert who basically ensures not just assistance is provided with respect to drafting of the ESOP policy, he also helps with the actual, management of the ESOP grants and issuance of shares pursuant to exercise of those ESOPs. So these are our three verticals. Now, when it comes to the contract ecosystem, it's very much like an iceberg. At the forefront is your external agreements, which a lot of our clients, based on our experience, they put focus on because that's where they think the money lies. Obviously, if it's an external agreement, it means your day-to-day business requirements with your customers. That's where it is revenue generating. Internal agreements, unfortunately, don't get as much importance because they're not revenue generating, one, and they're essentially for your internal stakeholders. These include your employment agreements, your internship agreements. Honestly speaking, some of our clients don't even think internship agreements are required until they, have problems where an intern is working for a competing firm or a competing company, and they realize that there could be a situation where there could be a breach of confidentiality obligations. So internal agreements, although you can't really see it, see the significance of it because they're not revenue generating, They're extremely important from a point of view of keeping your house in order. So we'll be quickly going through some of the external agreements as well as the internal agreements now. So external, obviously this is an indicative list. It's not an exhaustive list, and we've noticed that your list of agreements also depend on the nature of the business. So based on how your business runs, we accordingly tell you that, look, if these are your stakeholders, these are the documents that you definitely need in place, and these are good to have. But otherwise, most of the documents that we've indicated, actually all of the agreements we've indicated here are not good to have. They are definitely something you should have in place if you want to protect the company adequately. Now, everyone knows NDAs. We're coming to the external agreement first. Everyone knows NDAs essentially. The importance of an NDA is to ensure that any confidential and proprietary information that you share is adequately protected. And what constitutes confidential information becomes most important when you're talking about what information to protect and the exceptions to the confidential information. So NDAs is something I think everyone knows, so I'm not going to go into it at length. The second is service agreement. And I have an example for this. So basically what had happened was this client of ours had come to us and they told us that, we are engaging a third-party developer who will basically update our website. And, the website's already in place. He literally just has to fix things here and there and make it more appealing and just updates basically. So we told them that's okay. Even if it's an update, you need a service agreement in place. The counterparty had given them an NDA. I told them very clearly, look, an NDA is not going to cut it. This person is going to be not only in access of your IP, your confidential information, they'll also be creating something. There will be some form of value addition. So I told them very clearly that you will need a service agreement as well as an NDA. If an NDA is NDA is essentially a precursor to a service agreement. If you're looking to test the waters and you're trying to get quotes from several different vendors, I would anyway recommend entering into an NDA. But if you finalized a service provider, then just a service agreement would suffice. But just an NDA by itself will not suffice in any case. So this was our advice to the client as well. But the client was like, look, I really need this urgently. I'm just going to go ahead with the NDA. I said, okay, but these are the risks. And 2 months down the line, there was a problem with the engagement. The service provider was not up to the mark. They were like, Smita, what do I do? Like, how do I go about this? Because I did not execute a service agreement and there's no termination clause. I said, look, the only way to get out of this is now to have an agreement which you were anyway trying to avoid. It'll be called an exit agreement, which basically says that, look, whatever IP I've created is your IP. It's not mine, and my here is the service provider because they are exiting the company, the engagement. And it's to also record that everything they've created for the company is the company's IP. That the service provider has certain confidentiality obligations, and this is the exit piece which is payable, after which no claims can be made by the service provider against the engaging entity. So this was our advice to them. And obviously, again, it was reactive after something had happened, but we wouldn't recommend this at all. In fact, lots of our clients come to us after things have gone awry, and I wouldn't recommend it one bit. To ensure smooth sailing and to ensure that your focus is solely on the growth and upwards trajectory of the company, it's important you get a legal counsel involved. Ensure that all your contracts are in place. You have adequate provisions which protect the interests of the company. So this was the example for the service agreement. White labeling, SaaS, and API, I will anyway be discussing subsequently in the presentation. IP assignment agreement is, honestly, we've seen this a lot in early stage startups where the brand name, obviously, to ensure that, no other competing brand comes up with a similar name. What a lot of early stage startups do is they get the trademark registered in the name of one of the founders. And if you notice, when a funding actually happens, the first thing the investor will ask you is whose name is the trademark registered in. And if it's in the name of the founder, they always ask for you to enter into an IP assignment agreement, which essentially transfers all rights with respect to the registered trademark from the founder to the company, and also transfers the trademark itself to the company. So which is why we see a lot of IP assignment agreements also being entered into. Developer agreement, terms of service and privacy policy and collaboration agreement we'll be touching in detail in the subsequent slides. But there are again things that you should definitely have in place when it comes from, for instance, terms of use and privacy policy is mandated under the law. Developer agreement, collaboration agreements become very, very important when the counterparties are third parties that you're essentially dealing with. And vendor agreement, honestly, is, and we've not really noticed this in tech companies. Vendor agreements are more in the nature of, for instance, your manufacturing agreements, where you're actually outsourcing an essential element of the business to a third party, because a lot of the early stage companies are bootstrapped. But tech companies, which also provide a hardware element to their customer, could require manufacturing to also be outsourced, in which case something like a vendor agreement becomes extremely important. So those are your external agreements. Now coming to internal agreements. Co-founders agreement is essentially, just to give a quick background, is an agreement wherein two or multiple co-founders, if they're going to be setting up an entity and want to decide each co-founder's rights and obligations with respect to the company, those will be carved out in the co-founders agreement. Given the importance of this agreement, we will also be talking about this in depth in the later on slides. That's your co-founders agreement. Offer letter and employment agreement. Look, under the law, offer letter is not really a prerequisite. Lots of people can do away without it. The only idea of an offer letter is to ensure, it's like an precursor to an employment agreement. It basically says that, look, you are being engaged for this role at this capacity for XYZ as your remuneration, which is payable by the company. If you join the company on XYZ date, you will have to sign the employment agreement. But so offer letter is, like I said, a precursor. And if it's, I mean, it can be, it's one paperwork which can be done away with. But employment agreement, I would definitely recommend you have in place. And surprisingly, we noticed that a lot of companies don't have these in place. And while the law says that whatever an employee creates is work for hire for the company, it's very important you have employment agreements in place, because you also have other obligations that you need to tie the employee with. For instance, your confidentiality obligations, your obligations on non-solicitation, trying to ask the employee to ensure they stay on exclusively with the company. These are things which are not, understood. You need to have it in black and white. I'll just give you another example. So basically what had happened with this one particular client, the employee was on their way out, and what they had started doing during, this person had started doing during the notice period was soliciting current customers of the existing employer. And obviously they weren't very smart, because they used the employer's ID to actually send out proposals of the potential employer, and the current employer saw those emails. And the way to deal with it was there in the employment agreement. The employment agreement very clearly said that you will have confidentiality obligations which subsist your employment, termination of employment. You will have non-solicitation obligations which subsist your termination of the employment. So basically how they use that particular language to say that, look, you breached your obligations which continue to survive your termination of employment, and therefore you are being asked to leave immediately, and you will not be entitled to an FNF or even the ESOPs that were granted to him. So if you did not have an employment agreement in place, you wouldn't have been able to fall back on. So if this were to become a labor dispute, you have sufficient arsenal at your disposal to actually support the termination that is being taken, that is being done effective immediately, because some states under their local shops and establishments mandate a certain notice period. So you still have sufficient justification to ask the person to go effective immediately. So that is one. Now, consultancy agreements are honestly for people who are not engaged as all-time, full-time employees. These are your, whether it's for tax benefits or whether it's for these personnel who are being hired on a part-time basis or for a particular project, you definitely need a consultancy agreement, because unlike in case of employment agreement where the law says whatever they create is work for hire, consultancy agreement, there's no such thing. You have to specifically call it out in the agreement that, look, I am paying you for this, and therefore, since I am paying you, whatever you create is work for hire for me and is therefore my IP. So this specifically needs to be called out. And obviously your other obligations around, ensuring that they give representations, they can actually enter into an engagement with you and they're not breaching or using any third party's IP or any former or present employer's IP. All of this needs to be specifically called out in the consultancy agreement. Now, HR handbook, and again, HR handbook is basically a set of do's and don'ts for all of your employees and your personnel, which basically says that, apart from the employment agreement, obviously these are the things that you shouldn't do and these are the things you should do, whether it could be with respect to something as simple as your expense reimbursement. You can't ask me to reimburse you for business flight tickets. I'm not going to pay you for that. Basic things like that. And also things like exit related formalities. So again, an interesting example for this was this particular employee of a client messaged the resignation notice, like they sent it via WhatsApp. Now, there was nothing which detailed the exit process in the agreement. There was nothing in the HR policy itself. So at no point of time could they actually say that, look, whatever you've sent me by WhatsApp will not suffice. You need to send me a written email from an ID to so-and-so ID saying that, you would like to resign effective this date. So which is why, again, we had to be reactive and we had to introduce a detailed set of exit procedures, which should have ideally already been there. So HR handbook is one thing that a lot of people tend to overlook and not have in place, but we would definitely recommend you have it in place. POSH policy is mandated under the law. It's basically your prevention of sexual harassment policy. It's to ensure you have a body in place, which is the ICC, which basically ensures that if a complaint is made by a complainant, there are steps that are taken care of, again, which are in compliance with the applicable law, which indicate that there will be fair process followed. The complainant will be given an opportunity. So will the person who's against who the complaint is being made have a proper process in place to ensure that the correct, processes are taken care of and the complainant is adequately taken care of. So a POSH policy is definitely something you should have in place. And this, mind you, would need to be in place even if you just have female interns. Because the view is that the moment you have any woman employee being employed or a woman consultant or intern being engaged, it is very important you have the requisite policies in place to ensure that if a case of sexual harassment is made, you have the body in place, which is the ICC, who can take it and take care of the measures that need to be met out. So that's POSH policy. Leave policy is, again, each state has its own Shops and Establishments Act. You are mandated under the law to give a minimum number of leaves to your employees as per the law. Each state has a specific number of leaves that you are required to give, whether as casual leave, as earned leave, as sick leave. You will need to comply with that. If you give something over and above, that's okay, but that bare minimum definitely needs to be met. That's leave policy. Equal employment opportunity policy essentially is again mandated under the law. What we're trying to ensure is that the employer does not discriminate between its employee, whether it's on the basis of sex, your caste, anything else. It has to be, and these are all decisions with respect to recruitment, your pay. There cannot be pay disparity unless it's on the basis of actual metrics, like actual KPIs being met or not being met. It cannot be on other differences, such as, like I said, your sex, your caste. It cannot be on any of this, whether the person is disabled or not. You need to ensure that you treat all your employees equally. So that's your equal employment opportunity policy. Like I had indicated, this is mandated under applicable law. Last is anti-bribery and anti-corruption law. Honestly, this comes into picture a lot when funds invest, and more so US funds, because they need to ensure that the company is at all times in compliance with the anti-corruption laws, whether it's in India or the US, such as the FCPA. All this policy is really saying is that, look, at no point will you take a bribe or give a bribe, which helps you in any way. And if you do know of any corrupt practices that have taken place within the organization, this is the body that you need to make the complaint to, and the requisite measures will be met out by this body. So this is all this policy states. And honestly, like I said, this becomes a prerequisite for a lot of funds, because they themselves have a lot of FCPA related obligations. Now, coming to things that are mandated under the law, and like I told you that, when we talk about external agreements, we'll detail upon some of these agreements in detail subsequently. One of which is terms of use and privacy policy. Okay, so now both these are mandated under the IT Act. And while it's mandated under the Act, what we've noticed is a lot of our clients copy paste. They use other companies terms of use, which may not necessarily apply to them. In fact, they even copy the governing law, which does not make sense, because a lot of them copy from US companies. So obviously your governing law has to be Indian law, and you need to be compliant with the IT Act. Now, the IT Act prescribes a certain list of don'ts that you need to tell your user to comply with, apart from the other regulations and rules governing the use of the platform, the cancellation return policies. There are certain things mandated under applicable law which say that, look, as part of your usage of my platform, you cannot do 1, 2, 3, and this includes things like you can't say anything which is defamatory. You can't say anything which is against sovereignty of India. You can't do anything which brings in a malicious attack. All of these are mandatory under the law and need to be specifically called out. And in fact, when an actual funding happens, your investor council, if they do not find these points, the first point they're going to ask is, you need to draft your terms of use in compliance with the applicable law, that is the IT Act, read with the guidelines framed under it. So you need to have this. You also need to have a particular clause which calls out that, that the user agrees to receive communication. Why is this important? Because apart from using the details provided by the user to actually provide them services, if in the event you seek to provide other offerings, or based on the service usage, you've noticed that, this particular user usage has been in this particular manner, maybe if I offer XYZ more, they might be interested. So in those situations, it becomes important to specifically call out in your terms of use that, look, I may reach out to you, whether by way of email, WhatsApp, or SMS, and offer you my other service offerings. And, you are giving me your consent to do so by way of agreeing to sign up on the platform. So you need to specifically have this as part of your terms of use. Link to third-party websites becomes only to protect yourself. Look, if there are third-party websites or links available on your platform, upon clicking which they go outside the platform, it's very important you clearly specify that the moment you go out of my platform, please ensure you read the terms of use and privacy practices followed by the third-party user carefully before you actually agree to sign up with them. Why it's important? It's important so that you are protected. At no point of time the user comes back to you and tells you, look, I went to this third party because that link was available on your platform. This is only and only to protect you from any claims that may be made for anything done by the third party. Obviously, termination is just to tell them that, look, I can terminate you on you breaching the terms of use, or you undertaking any illegal activities, or if I deem fit for whatever reason. So you need to specifically enlist this, and you also need to tell them upon termination, your access to your account will stop and you will not be able to access any of the data unless under applicable law, I'm required to maintain the data for a specified period of time, which you are. You're required to hold on to that period for a specified number of months, post which you can delete it. Then there's the concept of grievance officer, again, which is specifically supposed to be put on your website, which basically gives the list of the grievance officer along with the details of how to reach out to that grievance officer, whether it's by email or phone number. You need to list out these details. Now, when it comes to privacy policy, please understand the moment you have personal information in your possession, it's very important you specifically call out in your privacy policy, what is the information you're collecting? Why are you collecting this information? Who are you sharing this information with? And what are you actually doing with this information? It's very, very important you call all of this out, because if for whatever reason personal information is being shared with third parties outside of the scope of the privacy policy, you are in breach. So it's very important to specifically enlist the third party service providers with whom you're actually sharing the information and the reasons for it. The reason could be as generic as, look, for the purpose of providing services. Let's, for example, take the case of an e-commerce marketplace. An e-commerce marketplace has to share your information with the vendor. It is important because they need to tell the vendor that this is the delivery premise that you need to deliver it to, this is the person, and these are the details of the order. So something as simple as that, you need to specifically enlist who you're sharing the information with if it falls outside the scope of your services. Again, like I said, consent for third-party service providers is required only and only if it goes outside your scope of services, in which case, please enlist at least an indicative list of people with whom you will share this information. Cookies, just a policy on what the cookie policy is, that the reason for the cookie actually holds a nominal amount of or a minimal amount of information, but if you do not want us to have access to that information also, you have that whatever means that we provide you. And opt-out is again simply to ensure that if for whatever reason a particular customer specifically says they opt out or they want to unsubscribe, you ideally should stop sharing information with them, unless again it's with respect to the transactions that they actually carry out on your platform. Okay, now co-founders agreement. A co-founders agreement is definitely required if you're entering into you're starting a business, whether it's with a family member or whether it's with a person who has subject matter expertise. It's very, very important that you have a co-founders agreement in place. And like, I would advise you to do this even if you're entering into this business with your own relative, because we've personally seen firsthand relationships going all right between brothers, father and son, and they're not having the requisite documentation in place because they assume that they're entering into an arrangement with a family or a relative, so it shouldn't be a problem. But I would still recommend that you have this in place, even if you have good relations with the particular co-founder. Also, it's important, and I'll tell you why. Like, for instance, recently we dealt with an exit of a co-founder. Now, they did not have any agreement in place with the co-founder, and now this person has not performed for the company for over 6 months. and it's known. And now it's become extremely uncomfortable to get the co-founder to leave. So obviously, we're more than happy to be that guy for you, wherein, we make it seem that, since you're leaving, we need XYZ in place. But again, if you had a co-founders agreement in place, it would have been written in stone, and you literally would just have to follow the process which is there in the co-founders agreement when it comes to exit of a co-founder. And you just have to have a simple one pager which says that, you're exiting the company and these are your obligations as part of your exit and post exit formalities. So it is very important to have a co-founders agreement, especially in a situation where you don't see funding happening in the near future. Why do I say that you shouldn't enter into a co-founders agreement if you foresee funding happening? Is because a co-founders agreement is essentially a culmination of an employment agreement and a shareholders agreement. So the moment you have an investor coming in, the shareholders agreement with the investor will supersede the co-founders agreement. So which is why if you do not foresee funding, please enter it into a co-founders agreement, which basically captures duties and obligations of each of the co-founders, which are specific to the role of the co-founder as a CEO, as a CXO position, whatever position the particular co-founder is coming in. It'll capture that. It will capture their share transfer related restrictions, vesting schedule, something as simple as, look, this is the shareholding percentage as on the date of this agreement, and how we're trying to ensure that the founder doesn't go out of the company is by ensuring that he's not entitled to transfer all of his shares at one go. So we have a concept of vesting schedule, which basically says that whether it's within a quarter, whether it's in a month or on an annual basis, his shares will slowly get released and he can start transferring his shares. So that is why it becomes important to have a vesting schedule in place. Now, decision-making authority, honestly, it depends on what is the commercial understanding. If you think it's fair that both parties take, assuming a situation where there are two co-founders, if both co-founders are comfortable with all the decisions being taken by both the co-founders, it's okay. But if you see a situation where, and this, again, I'll give you an example where this company was essentially founded by a single co-founder with his wife. Getting in 2-3 other co-founders, he still remains the main co-founder because one, he took the initial risk. He founded the company. He handled all the incorporation expenses. He took care of all your trademark registration. So it's only fair he has a say in some of the more important matters. For instance, funding, he wanted to have a say. He wanted to have a say on any strategic partnerships, any contractual agreements which go above or beyond threshold. So those things he specifically wanted a veto right over. Others could be decided by the co-founders who are also directors by way of simple majority. So which is why it becomes important if you think that one co-founder should definitely have a say, or let's say there are 5 and 3 co-founders for sure should have a say in one particular matter, that needs to be specifically called out in the co-founders agreement. And last, like initially I talked about exit of a co-founder, you need to call out when can a person exit. A lot of times what people want is to attach a lock-in period wherein the co-founder has to stay with the company for a certain period. He can't even transfer his shares during that period and make it subject, again, like I said, to a vesting schedule. And if he were to exit, these are the consequences. If it's a good leaver situation, then this is what will happen with his vested shares, with his unvested shares. If it's a bad leaver situation, more often than not, he's asked to sell all of his shares at par value because, look, we're trying to make sure this is a deterrent and we're punishing the co-founder and not actually helping him exit the company. So these are the 4 things that definitely need to be called out in your co-founders agreement.
So yeah, I think someone had a question.
Smita, regarding the vesting schedule for co-founders,
yes,
it's for ESOPs, it's usually around 4 years, right?
So ESOP also has a mandatory cliff period,
Yeah, 1 year.
after which you can have a vesting schedule of however long you want. Yes, it's typically 4 years. But for a vesting schedule for co-founders, we've seen anywhere between 3 to 5 years, not longer than that. Because longer than that is holding someone back for too long. And vesting schedule depends. If you want to vest it on an annual basis, on a monthly basis, or quarterly basis over the 5-year period, is a complete commercial call. But we've seen lock-in period, which is essentially a vesting period, being as long as 3 to 5 years.
So you're saying, like, if we have a vesting period of 5 years, a co-founder is free to leave after 5 years with 100% of his vested shares.
Yes. So even there, I mean, even if the shares are fully vested in him, we can add certain restrictions on him in the form of ROFR restrictions. That's your right of first refusal, so that you do not bring any third party who we are not comfortable with. So if the remaining existing co-founders can buy him out, or existing co-founders can identify a third party who can buy him out, you can do that. That is one, a ROFR restriction. And the second is tag along. Look, if you're getting a good price, I mean, if the exiting co-founder is getting a good price, if you also want to tag along with him, you can. So we've seen share transfer restrictions also apply, irrespective of whether the lock-in period finishes. So even if all his shares become completely vested in him, he will continue as a shareholder to have certain share transfer restrictions.
Got it. Yeah, thank you.
No problem. Okay, moving on to SaaS agreement, and we'll be dealing with API agreement also, which is sort of similar, but the nature of the services are different. SaaS agreement, we only have a platform, and a lot of times, and our clients are all like, I'm talking about it from a perspective of an early stage startup. They really need the revenue. So they, like I said, they do not give significance to contracts at all until something actually goes wrong. But we keep pushing back and telling them, look, you need to have a template in place. You need to tell the counterparty that, look, these are my minimum things that I definitely need. And the way to do it is to have a template in place, because when you're an early stage startup, it becomes a David versus Goliath case. If you're dealing with an MNC, no MNC is going to be comfortable with you giving your template. I mean, I'll be really surprised if a large MNC is agreeable to using your template. But what it does is it gives the MNC an idea of what you want, what you definitely need. So even if the MNC were to give their own draft to you, you can mark it up. You can say that, look, this was already there in my SaaS agreement. And these are things like scope of software license. You need to call out in the agreement that, look, I'm giving you a limited revocable license to use my software simply for your internal business use. You are not allowed to reverse engineer it. You are not allowed to create a competing product based on whatever knowledge you've learned from my software. And you need to use it only for your personal consumption. You cannot be giving the access to it to a third party without my prior written approval. So this definitely needs to be called up, because look, this is your product. Like, you put in your money and blood and sweat and tears into it. It's important you protect your main product, your IP, the backbone of your company. So it's very important that you specifically call out what are the terms of the service or the license that you're actually giving them. Support services become important only to tell them that, look, I mean, this is the form of support I'll provide. This is the escalation matrix. Depending on the nature of the problem, these are the people you need to reach out to, and these are the resolution periods. It could be as simple as that. You needn't have a separate SLA in place, but it's important you specifically call it out, because if there is any claim made by the counterparty, you have done everything. You've checked all the boxes as per what you were supposed to. And one of those boxes are support services. You specifically need to call them out. Ownership of IP, like I've told you, this is your IP. You need to clarify in the agreement. I understand it's self-explanatory, but it's better. I mean, from a lawyer's perspective, I'd rather have it in black and white than have it understood. So I'd rather have you clarify it multiple times as a measure of abundant caution, then, you know, for me to later interpret that, look, since I've given you just a license, it's understood that it's my IP. So I would request you to specifically call that out. And obviously white labeling becomes, and we've noticed this as a trend, when the MNC is particularly happy with the SaaS product, a lot of times they come back and say, look, why don't you give me this particular product? I'd like to, you know, use it under, offer it under my brand name. That's essentially white labeling. And please understand, MNCs have a larger network. They can reach a larger audience. So therefore, they're actually eating into your market. So just be a little careful when you're white labeling the product. You specifically enlist things like even territory. You ensure that whatever customers you are currently servicing, they don't service. There's no predatory practices, for instance, because they have the, you know, they have the costs and expenses in place. They can maybe give discounts which you can't necessarily offer. So you please ensure that you have all of these things specifically called out in your white labeling agreement. And limitation of liability, again, this is something that's a pain point and it becomes a huge negotiation thing. We've faced lots of back and forth. The limitation of liability clause is very important to ensure that you say that, look, I will be liable up to a certain amount, and this amount is typically how much ever benefit you're getting out of the contract, which is essentially your service and license fees. So let's say you've agreed to a service fees of 10 lakhs, your cap should be 10 lakhs. And it's for the court to decide. A lot of times, see, you need to understand, if you give your intent clearly in the agreement, the court will look at the agreement and try to interpret that, you know, this was the intent of the parties. Since the parties intended it to be 10 lakhs, and it's for the court to then decide whether it's a reasonable cap or not, given the risks that the counterparty has actually gone through. But they'll still go through the agreement. They'll still try to ascertain whether this cap makes sense or not. And if it makes sense, then you actually on day zero already know that my liability or my risk from this particular contract is only 10 lakhs. And please understand this, uncapped liability is a huge red flag for investors. The moment they see agreements which do not have cap liability, they get very, very uncomfortable, and they set it out as part of their specific indemnity clause in their transaction documents, that if something were to go wrong, then you need to indemnify investor for this contract. So which is why it's very, very important that you have capped your liability at a certain amount. API agreement is essentially the, the similar points to what we discussed for SaaS agreement. Again, because this is an integration of API, you need to be very careful when it comes.
Hi, Shrutika, is it just me or is Smita's screen frozen?
Yes, I think there's some issue. I'll just quickly check with her.
Okay, no problem, it's fine.
Hello?
Hi,
Yes,
Smita. Yeah.
you're back.
I'm so sorry. I live in Tirupati. There's a scheduled electricity cut at this point of time. I'm really sorry.
That's all right, no problem.
Okay. So the API integration agreement is essentially, again, the set of points that I discussed, but additionally, you need to specifically capture, since you're integrating with a third-party software, you need to have clauses around security breach. What happens in case there's a security breach on behalf of the counterparty? How do I need to ensure I'm protected? Because look, you are giving your API to them, so you need to be very careful when it comes to an API integration agreement, you specifically calling out the list of processes and steps that you need to take, both parties, in case of a security breach. Again, disclaimers, both in API and SaaS agreement, and we've seen people argue about this for months on end. you need to specifically call out that, look, I am giving you the services on an as-is, as-available basis. Apart from the basic representations on service, on IP, etc., that I've given, to the best of my knowledge, I will not give you any other representations and warranties. I will not give you implied warranties of merchantability, of uninterrupted use, or of the use being error-free. You need to specifically call these out. Technical support becomes a little more important in case of API integration, whether it's remote or in-house or on-premise. You need to, depending on the nature of the service, you need to specifically have this in place. And we've seen banks, like we deal with certain clients who are not regulated entities, but in the fintech space, who deal with financial entities on a day-to-day basis. And because of the RBI outsourcing guidelines, it's very important that they have an SLA in place. They have a specific, disaster recovery mechanism. They have BCP in place. We've seen all of this. So it's very important that at least, at the very least, because you're not a regulated entity, you have a technical support or an SLA in place, which basically sets down that, look, if there's a planned maintenance, I will let you know in advance, or planned maintenance will take place between this to this hours, which is typically off business hours. They're not during peak business hours. And you will also tell them there could be situations where there's unplanned maintenance, which is due to no fault of mine. So all of this needs to specifically be captured in your API integration agreement. Again, ownership of IP, like I said, since both parties will give access to their software, it's very important to tell them that, look, all my IP is mine, all of your IP is yours, and neither party will at any time breach the other party's IP rights. So that specifically needs to be called out. Now, developer agreement is the next agreement, and this, like, it's a fact that techies are really expensive. In fact, hiring a techie is, more cost exorbitant than hiring a lawyer in today's day and age. So it's very important. And we've noticed a lot of our bootstrapped companies which are in the tech space, they prefer engaging third-party companies which have the requisite workforce and personnel to actually build an app for them, or a platform for them, and keep it ready for the the company to actually provide services. So in these agreements, and this is an example that I was giving you earlier on, that someone was actually updating the already existing website. This is also applicable when someone is building something for you from scratch. And I will give you another example. We had done a preliminary draft of a developer agreement, wherein this third party was developing the app and the platform from scratch. So all that we said that, look, all right, with respect to whatever you build, including the source code, is my IP. The moment the developer saw this clause, they got uncomfortable. They immediately took a step back. They said, look, I can't sign off on this. I am planning to use the source code for other clients as well, because obviously the developer was looking at it from a cost-effective purpose. They were looking to learn from this particular assignment with our client, use the source code and develop other apps and spend lesser time. So the moment the client came to know this, they stepped back and they said, I'm sorry, but you're building this for me from scratch. I'm paying you a huge sum to actually build it. I want all rights. And that deal did not go through. And they were very, although they were sad that they had to again be on the scope for, look out for another new developer, they specifically told me that they were happy that this engagement didn't go through, because at least they knew from the beginning that, look, this was the intent of the developer. So in your agreement with the developer, it's very important you clarify, again, like in case of service agreement, like I told you earlier, whatever you build, whatever you pay for is your IP. You need to specifically say that. Even in a situation, let's say you've terminated the agreement, as long as you've paid for a certain stage, because a lot of developer agreements we've seen are, based on parameters or based on milestones that you make payments. Whatever milestone you think you can actually create a viable product out of and you've paid for, I would recommend you clarify that in the agreement clearly. Look, that's my IP. Since it's my work for hire, like I said, since you paid for it, you have all rights with respect to whatever IP is created. And you also specifically call out conditions saying that, look, and we've seen this in a lot of engagements as well, where the developer was actually building something completely new. Although this developer is in the business of creating apps, so on and so forth, what they clearly told in the agreement was, at least during the term of the agreement and for a period of 6 months, you cannot work with a competitor. You can work in any other space. You can't work in this particular space in which the company is, doing business in, simply for the reason that the person is in such close contact with the actual proprietary and confidential information of the company. So it's very important the company protects this. So you should add non-compete and exclusivity clauses depending on the nature of the services and the deliverables being created out of the engagement. And obviously the last point is, you will not build anything that's actually infringing a third party's rights. You should have taken the requisite third party approval. Your last is your collaboration agreement. And this is for any sort of collaboration, whether it's with a channel partner, someone who's a reseller, someone who's a distributor. It's essentially falling under the bucket of a collaboration agreement. What you need to ensure specifically, given the premise of the arrangement. So for instance, let's say it's a channel partner agreement. You specifically need to say in the collaboration agreement that, look, the only right I'm giving you is to promote and market my services. And you need to refer back all the leads you get from those promotional and marketing activities to me. You at no point will go ahead and take orders for me unless it's something commercially, you're agreeable to. In case of a distributor agreement, you give an additional right of actually allowing them to distribute it and take orders for and on your behalf, but you still continue to being the service provider to the intended service recipient. So it's very important to specifically enlist the right you're agreeing to give to the partner as part of the collaboration. Now, promotional marketing activities, why it's important to call out and like why it's become a pain point is because you need to tell them that don't misrepresent, my product. Don't go tell that I'll give you 100% uptime, because you can't. That's not practically possible. So, don't misrepresent my product or me. Don't disparage my product or me. Ensure all your marketing and promotional materials are either provided by me or signed off on by me. So it's very important to specifically enlist this, given the nature of the arrangement. Non-compete, again, honestly, is something you can think about. A lot of people are not comfortable with allowing the partner to work with a competing, business, or even start a competing business, again, for the simple reason that they are in touch with your pricing, what the product actually does, and they can basically become, a competitor or become, an accomplice to a competing business, which could undertake predatory practices and therefore eat into your market. So it's very important to specifically enlist that depending on the nature of the collaboration. Channel partner, honestly, we don't see a lot of non-compete obligations. We do see that you do not push a competing product, but we do not, honestly, in a channel partner agreement, we don't see a non-compete because it's essentially a referral arrangement. And last is incentive and payments. You need to clarify that, look, on this event only happening, do I pay you? And that is typically when I actually receive payment from the client. Only on that I will pay you, and this could be a rev share or this could be a fixed price depending on whatever you've commercially agreed. But these are very important to be specifically captured, because we've seen situations where the channel partners asked for his or her fees immediately on them referring, which is not fair. Until it materializes and actually becomes revenue to the company, the channel partner should not get paid. So these are some things you definitely need to capture. So as part of our presentation, the intent was to capture the important agreements and the pain points and things which you definitely should add in your agreements with both internal as well as external stakeholders. That was the end of our presentation. I'll open the floor for any questions that anyone may have.
Yeah.
Can I, Smita?
Sure, Vipul, please tell me.
Yeah. So looking at the number of agreements that a startup has to have, and the kind of situations that can arise, at various stages, right? So, I mean, an in-house lawyer would not be viable at the initial stages, right? So, an outsourced agency, should we have an arrangement with an agency, and will there an agreement required between us and the agency as well?
So see, that's what a lot of our clients are all bootstrapped, or they've just recently raised Series Seed or Series A. Very few of our clients are actually Series B, because by then they need a lot of agreements to actually be vetted. But till Series B, Series C, we have had clients, and honestly, we still continue to have clients. The idea is, if you go out into the market and look for a legal counsel, since you're bootstrapped, it's going to be very expensive. It does not make sense. So which is why we came up with the idea of outsourcing all of your contracts work to a team. There's an entire team which will be looking into your work. There's not just one individual. So you are taken care of by, for instance, I'll just give you an example. For a particular client, we had 3 lawyers who worked on that client's work only round the clock. So in the initial stages, I definitely would not recommend you getting a legal counsel, because we know for a fact that cost becomes a challenge for early stage startup ecosystem. So it's very important you outsource it to a third party. And the idea behind, like I said, the third party makes it simpler because it's not just one person. So even if one person leaves, there's a team of 7 to 9 people who are already there, who will continue to work. So you will not get impacted. The SPOC may change, but you will at no point get impacted. But if you were to hire an in-house counsel leaves, you go back to zero, right? So I would always recommend, especially in the initial stages, to outsource legal and compliance work. But obviously, depending on a cost perspective, if you have the requisite cost, then you can have it in-house, but I would still recommend you outsource it.
And what will be the approximate cost, for the entire bouquet of services that you offer?
So it really depends on, because a lot of times we're looking at it from a long-term perspective. I honestly don't look at it as a one-time engagement. I want you to be with Lexstart for at least 2 to 3 years. I want to see you grow. So what we do is we set up an introductory call. We understand the stage at which the business is. We understand how recurrent are your contractual requirements. And then we give you a customized fee for you, because look, we completely understand we're dealing with startups, so costs need to be taken care of. We do not want to make your life more expensive. We want to make it easier. So we will give you a more cost-effective proposal, and we don't have an idea of a graded rate. Like, for instance, I'm an associate partner. I have more than a decade of experience. I have Shrutika, who comes with a couple of years of experience. Tara with a year's experience. I have a senior associate who comes with 5-6 years of experience. So we offer all of us at a single rate. The idea is to ensure the costs make sense to our client. We look at it from that perspective. Like I said, we grow with you. So if you grow, great. If you don't grow, we continue to make, give you rates which make most sense for you from an economic standpoint.
So it is.
If this is something you would like to explore, Adi, if you could separately share our details with Vipul, I'm more than happy to take up a preliminary discussion with you and understand your requirements, and based on that send you a specialized proposal.
For sure, Smita. Actually, if anyone else from the cohort maybe needs a one-on-one, and if we can if they can let me know, I am very happy to set it up in the maybe end of this week or early next week.
Sure, I'm more than happy to talk to Vipul, and if anyone else also wants to have a preliminary conversation. I understand we've already outstretched our time. I didn't realize the presentation would go on for this long, but I hope it wasn't overwhelming, and I hope I did not give too much information. And the idea was to just set the context. Obviously, I'll help you understand better once we have a one-on-one.
Sure. Perfect. Smita, that was great. I think all the startups might have benefited a lot from that. It would be great if you could just share the slide. Are you okay to sharing the slides and the PPT with the cohort?
Yes,
And in case there's anything, I'm happy to connect and make a one-on-one conversation anytime.
sure. No problem. More than happy to share this.
Perfect.
Okay.
Fine. Thank you so much, everyone from Lexstart who are there on the call. Thank you to all the startups.
Thank you.
Thank you.
Bye-bye.
Bye bye. Thank you.